The agency relationship for the national portion of the real estate exam can be severed through 7 specific methods that every candidate must master. The most common way an agency ends is through the completion of purpose, where the objective of the relationship has been met. For example, when a listing agent successfully navigates a transaction to closing and the deed is recorded, the agency relationship with the seller terminates because the job is done. You no longer represent that party, and your authority to act on their behalf ceases. Another essential method is the expiration of terms. Every listing agreement must include a definite expiration date, and if that date passes without a successful sale or a written extension, the agency relationship ends automatically. You should be prepared for trick questions involving a broker who attempts to claim a commission after a listing has expired. Unless a specific safety clause or protection period is active, the expiration of the term effectively kills the agency and the broker loses their right to represent the client. Mutual agreement serves as a third method and functions much like a voluntary rescission, where both the principal and the agent decide they no longer wish to continue the professional relationship. If both parties sign a document to terminate the agreement, the agency is dissolved, and typically neither party is liable for a breach. However, the exam often focuses on the operation of law, which includes death or incapacity. A primary trap involves the distinction between the death of a salesperson versus the death of the broker. Because the agency relationship is legally established between the principal and the brokerage or the principal broker of record, the death of an individual salesperson does not terminate a listing agreement. The listing belongs to the firm, and the firm will simply reassign the case to a different agent. Conversely, the death of the seller or the death of the principal broker will terminate the agency immediately by operation of law. You must remember that the contract is with the legal entity or the broker, and not the individual salesperson who did the paperwork. Property destruction, such as a house being destroyed by fire or taken through eminent domain, also terminates the agency because the subject matter of the contract no longer exists. If there is no property to sell, the agency cannot continue. Bankruptcy of either the principal or the broker also terminates the agency through operation of law because it results in the loss of legal control over assets. This is a common involuntary termination point that appears on many versions of the exam. Then we have unilateral termination, which includes revocation by the principal or renunciation by the agent. While either party always has the power to terminate the relationship, they may not have the legal right to do so without penalties. If a seller fires a broker without a valid legal reason before the contract expires, they might be liable for marketing expenses or a full commission if a buyer was already found. The exam frequently tests your ability to distinguish between the power to quit and the right to quit. To keep these 7 ways straight, use the phrase, "Can every mature dealer deliver better understanding," which represents completion, expiration, mutual agreement, death, destruction, bankruptcy, and unilateral termination. A vital point for the exam is the status of fiduciary duties after termination. While loyalty and obedience end, the duty of confidentiality survives the termination of agency indefinitely. You must keep a former client's secrets forever unless a court order intervenes. If a question asks if you can disclose that a previous client was under financial pressure, the answer is always no, because the duty of confidentiality never expires.